Hello and welcome to another edition of In the Trenches podcast. I'm your host, Seth, and with me are two very special guests for our Constitution Day special. One of them is Hadley Arkes. He is the director and founder of the James Wilson Institute and the Edward Ney Professor Emeritus of Jurisprudence at Amherst College. He has written many books on the intersection of the natural law and the Constitution, such as First Things, Beyond the Constitution, Natural Rights, and the Right to Choose, with another forthcoming book called Mere Natural Law. Among his contributions to our law, he was primarily the architect of the Born Alive Infants Protection Act and the Defense of Marriage Act. Another guest with us is Garrett Snedeker. He is the deputy director of the James Wilson Institute and a JD student at the Antonin Scalia Law School. He has written articles in Newsweek, The Federalist, the American Mind, Law and Liberty, and now James Wilson Institute's own online journal called Anchoring Truths. Welcome, both Hadley and Garrett. It's nice to have you on.
Well, thanks for inviting us.
Thank you.
Professor Arkes and Mr. Snedeker, I thought we'd start up by me asking you just, what can you tell us when we're talking about the Constitution, and how do you understand the structural Constitution differently from the Bill of Rights?
Well, let's unpack that. You have quite a few things there. Well, let's take this back for a moment to that night after Barack Obama won the election for the first time, and he was addressing a throng in my hometown of Chicago, and he said, "We've built this country, calloused hand by calloused hand, for 221 years. The next morning, I had an email from Jim Stoner at LSU. Did you see, this is heresy? He said 221. In contrast to Lincoln saying at Gettysburg 77 years ago, we brought forth this country. Obama took the beginning of the country with 1787, the drafting of the Constitution. Lincoln took it to the articulation of that first principle that articulated the character of the regime. Remember, he used to use this line from Psalms: "A word fitly spoken is like an apple of gold in a frame of silver. The frame was made for the apple, not the apple for the frame." So his understanding was the Constitution was made for the Union, not the Union for the... Where does the Union begin? With the articulation of the first principle, to indicate what kind of a regime we have in the Declaration, that the only rightful governments of human beings had to depend on the consent of the governed. Remember, Lincoln would later say, the question is whether the black man is or is not a man. If he is not a man, anyone could do with him what he wishes. But if he is a man, that he too would have a right to be governed only with his own consent. Okay? The test for a constitution was to give us a structure of governance that's consistent with those underlying principles. And this is, as Justice Southley's remarked for us, this is the second constitution we've had. The first one proved effective. It was just abetting the centrifugal tendencies at work in the society. So what we hear as a structure of governance, there may be different kind of constitutions compatible with those first principles articulated in the Declaration. You could have a parliamentary system, have a presidential system. But people say, well, why do you need the Constitution? We do need a structure. We do want to know whom the military is supposed to obey if a president dies in office. I do want to know whether a state can make its territory available as a military or naval base for another country. Okay, those are structural matters about how the country is governed. The Bill of Rights now was trying to make explicit some of the principles people thought could be overlooked, but people, even lawyers and judges, forget that there was a serious argument about the Bill of Rights at the very beginning. That people we call now the Federalists were very reserved about the Bill of Rights, not because they were reserved about rights, but because it would foster a kind of misinstruction about the ground of our rights. And you get that when you hear people say, those rights I have through the First Amendment, as though you mean you wouldn't have the right to assemble, to publish, if there weren't that First Amendment. That you have these only because it comes to the positive of the law, posited or enacted. And that's part of the concern. That people would think that those underlying natural rights we have, that were there before the Constitution, that the founders drew upon as they framed the Constitution, those would not exist if they had not been explicitly mentioned in the text. And so the recognition is that, yes, you have rights that run well beyond the text. And that the Bill of Rights may have a function at times of narrowing our sense of what of who are the people to be protected. The unborn child, the people who suffer wage price controls, who can't make a living because the government has imposed controls upon what they can make in their businesses. No, somehow some of these things don't come into sight because they're not mentioned in the Bill of Rights. So the Bill of Rights, it sometimes works as a kind of screen to put the focus somewhere else and to put out of sight other things which we could deliberate if we were simply deliberating about who is a human person who properly receives the protection of the laws. That would be an entirely different ground. That's as with Lincoln, you'd say, is the black man a man? Is that unborn child a human being? All right, we not question whether unborn children are mentioned in the text, but the question, but moving again to the ground in which we deliberate about any of these things.
Just to build off of what Professor Arkes said, this is a podcast in honor of Constitution Day, and we'd be derelict in our duty if we did not inform your listeners that next to James Madison, it was our Institute's namesake, James Wilson, who was chief in shaping the Constitution. Wilson gave us those words from the preamble, "We the people," meaning we, as in we were, even before Lincoln articulated that these were no longer these United States, but the United States, that sovereignty began in each individual, in the man. It comes back to Hamilton's construction in Federalist 84. Here in the Constitution, the people surrender nothing. The Constitution was not meant to be like the Bill of Rights in particular was not meant to be the 10 Commandments. It wasn't meant to articulate all of our rights, but rather a document, a positive law, a set of positive law rights that are meant to articulate or provide a window into deeper natural law obligations, duties, as well as rights.
In other words, thinking about Wilson's point that, well, Blackstone said, entering civil society, we give up those unrestricted rights we had in the state of nature, and including the liberty to do mischief, to which Wilson said, well, when have you ever had a liberty to do mischief? The laws that restrain you from murdering and raping are never restraining you from anything you had a rightful liberty to do. So as Garrett said, Hamilton said in the Federalist 84, here the people surrender nothing. We don't, as James Wilson said, it was not the purpose of this Constitution to surrender our natural rights, to invent new rights, but rather to secure and enlarge those rights we already had by nature. Getting back to the ground of natural rights.
So I think some critics of maybe your view of things would say, aren't you elevating the Declaration or those principles over the Constitution? And if so, what do you say to those people? Because there are mainly in the conservative side who maybe take a more view of just looking at the Constitution only, rather than the principles and the philosophy that ground our Constitution. What do you say to those people?
Well, they're suffering some confusion about this matter, that the Declaration of Independence reflected certain principles of natural law, but it also provided a certain kind of guidance in critical things in our law. Lincoln, in his first inaugural, explained in a careful way, by the rule of a majority that understands there are constitutional and moral limitations on what a majority that understands it cannot do everything. That is the only operational form of the government by the consent of the government. Now, but our principle for that, this is the form of government that is necessary. That was in the Declaration. The only rightful form of government over human beings is that which depends on the consent of the governed. But of course, as Scalia used to say, well, that principle was never enacted. Well, it couldn't be enacted for the reasons John Locke explained. We said, what is the source of the law? The legislature. What is the source of the legislature? The Constitution, which tells us whether we have a legislature, how many bodies. Then what is the source of the Constitution? He says it must be some source wholly antecedent to the Constitution itself, which tells you in the first place why you have governance, why you have a constitution. So the problem is, if we only have the rule of majority, understood as a principle in itself, utterly detached from that anchoring principle, then the question is, why does the majority rule? Well, Justice Holmes and Justice Scalia put it this way, that because it can overpower the minority. Detached from that principle, the government by the rule of the majority simply turns itself into the rule of the strong, or might makes right. Okay, but so the Declaration, again, as you suggest, brings us back to those principles that had to be in place to explain why is it that people can be bound by a law? Why are some people in the position of having their edicts or their judgments treated as binding law on others, even to the point of displacing their personal preferences and restricting their freedom? That the writers on politics have taken over the years as the opening question of these things. And then there's a question: if before we set up a government, what form of governance is more compatible with the nature of those beings who alone are capable of framing propositions that could be valid for others as well as themselves? Or they alone, the only people who could be the subjects of law, the only people who could be sensitive to the teachings of the law, matters of right and wrong, and understand what it means to bear an obligation. So sure, you're right. The Declaration keeps bringing us back to those things that antecedent to the Constitution, and which the founders drew upon. As how do you know that what required them to form this kind of a government? They were there before the Constitution. What made them frame it this way? In order to do that, you've got to understand what they knew, the sources of moral and legal judgment they could draw upon before we had the text of the Constitution.
Okay. Go ahead, Garrett. Sounds like you were going to say.
I'm sure your listeners are quite familiar with the writings of Lincoln. Seth, I know you stand in often for the Jaffa position. Your co-host, Cal, stands in for the Walter Burns position. So your listeners will certainly be familiar with how Lincoln himself understood the Declaration and the Constitution in being related to one another, right? Lincoln analogized from the Bible that the Declaration was like the apple of gold within the Constitution's frame of silver. The apple was made for the frame. The frame was made for the apple, not the apple for the frame, right? If we're to understand the principle of all men created equal, at the heart of the Declaration as being a principle that holds true in all places and at all times, then the Constitution must always be pointing towards that standard of judgment. But the Constitution itself, is of course, structural. That's what we were just discussing. And so there will be those instances in which we're dealing with second order questions of, right, what's practical? How are we going to reconcile, certain branches and their internal practices and their precedents with one another? But when those internal practices and precedents are in tension with that central principle of all men are created equal, and of course, all men are created equal is just one of many natural law precepts. That's when we reach the point where we understand that the American experiment itself is truly one in which we can base it off an external external standards of judgment, and one in which it truly does call us to judge ourselves against something higher than just law that's been posited by fellow men.
I mean, I'm glad you talked about more in judgments and all, because one of the things I think people are skeptical when it comes to natural law is the fact that maybe we don't always agree about what is quote unquote true. Hadley, I know you have a really good answer to this, which is why I wanted to bring this up with you, because it seems like a lot of people today just don't believe there are truths. That, for instance, like all men are created equal, because we don't all agree on those type of things. So, what do you answer to those skeptical people?
First of all, the confusion is overthinking that the test of truth is agreement. You may have all kinds of eccentric disagreements with things that are firmly, even like the existence of males and females. Now, as I took that proposition we hear so widely, that if there were these truths that hold in all places, we'd find agreement in all places. But the very fact we find disagreement must stand as prima facie evidence that there are no such truth. Now, I said it reduces to this proposition: the very presence of disagreement on any matter must indicate the absence of truth. And of course, I say, well, I register my disagreement with that proposition. By its own terms, it collapses. It's simply a self-refuting proposition to argue in that way. If there's any ground of truth for the proposition, will have to depend on its own internal evidence, or the supporting evidence. So that look, I discovered that line about there's no agreement about these principles. In fact, if we understand what they are, we find there's no disagreement about them. And I'll get that back to a moment. But I think Justice Gorsuch, in his recent book, said, those of us who are originalists, this is people who begin with Scalia, that we have no agreement on the principle of natural. Guess what? People who are textualists and originalists find themselves disagreeing. But that doesn't apparently jar their confidence that textualism and originalism have truths to discern and to deliver. So let's just get past the self-refuting proposition that the very presence of disagreement must indicate the absence of truth. So let's look at the case itself. Now look, let's start with what James Wilson and Kant both recognize as the first principle of all moral judgment, is that it makes no sense to cast judgments of praise or blame, right or wrong, on people utterly incapable of affecting the act. If you're told that Jones was in intensive care at the time the burglary was committed, or Jones had not been born at the time the act was committed, we take that as prima facie evidence for his innocence. Well, that simple proposition threads through so many parts of our law, whether it's the insanity defense, he wasn't in control of himself, maybe even part of what the wrong we find in racial discrimination. You're saying that you think that people are governed by the race, they're governed by forces outside their control, and so on. Well, you could give that proposition. It's wrong to hold people blameworthy or responsible for acts they were powerless to control. You give that to ordinary people, the man on the street, and he sees it instantly. He would not hope, he wants to see Jones prosecuted for something done when he was in intensive care. So on this point, there's nothing imprecise about it, and it does not elicit wide disagreement among our people or anyone else everywhere. These purposes would be recognized anywhere. So you get these lives when people don't see where the natural law finds its ground in those axioms of reason, as John Marshall said, or those propositions that are so true, so necessarily true that we just must, as that my friend Dan Robbins used to say, we must take them as unavailing, simply in getting on with the business of life. Okay, and there you find ordinary people suffer no problem. They don't find these things inscrutable.
Okay.
Yeah, let me get Garrett Benjamin.
So, I mean, you alluded to this pretty much, and my next question was, are there limits to these principles? If the sole domain of judges is to articulate those limits. So, you kind of alluded to it when talking about the insanity stuff, but could you elaborate on just what the limits of those natural law principles are in any given case? Because I think some people might see that, that there may be a certain case that a principle of a natural law only goes so far. So I was wondering what those limits could be.
Well, I say those principles will not tell you what the proper price is for a pair of pants, how many divisions they take. They'll give us the axioms of judgment. We used to use this old example of the visitor who comes in from abroad, lands in New York. We don't have to look at his passport before we protect him from a violent assault on the street. We don't think that his claim to that protection of the law would hinge in any way on his citizenship. Okay, there must be something called some rights that attach simply to human beings as human beings. At the same time, he can't take himself over to the City College of New York and expect to enroll at that subsidized rate of tuition that the citizens of New York are willing to make available to people who live and work there. Okay. Now, let's see, a judge can tell us that. The judge can say, there are rights that arise under this Constitution. There are rights that arise for any human being. But there's certain rights that depend on enclaves, like the right to use the squash courts at Amherst College. That depends on the sufferance of the local community, what they're willing to provide. Your right to get a subsidized education in New York. Or now, how long should the residence requirement be before a resident alien should be able to claim that? Now, my point is, there's nothing in the kit of judges. There's nothing in the principles of natural law that will allow you to make that kind of description. When you're dealing with empirical things, but the first principles must be in place as to why you understand why local communities are justified in making those restrictions, and why there's nothing in the principles of natural law that get into those minutiae that tell you what we have to tell you. Can say whether it's legitimate for you to make certain provisions of this kind, but it will not tell you what exactly the residence requirement should be. We're dealing quite beyond the reach of the principles of natural law. But the natural law must mark the boundaries of things. It will tell you, first of all, why you would not withhold the protection of the law from a human being who happens not to be a citizen.
So the other way that oftentimes we hear this construction is, I'm a good conservative. I've grown up in a culture, though, that's utterly hostile to conservative positions. And so as a matter of high prudence, this culture that's been shaped by rogue judges largely, as a matter of high prudence, executives, legislatures, those are the more proper constitutional actors that should be able to articulate ultimate values, not judges, right? If judges can articulate ultimate values, then we've truly lost the rule of law. Now we're truly in the rule of men. But how we at the James Wilson Institute approach this differently is by thinking of judges as nothing other than just a co-equal branch in the constitutional scheme. And if judges can't make as capacious and coherent an argument as the other two branches, then what we've done is we've rendered an entire branch of our government, the judiciary, that should be using as the currency of their trade, the giving and taking of reasons. We've given them, probably the most diminished toolkit possible. And so we would, we take Lincoln in the Dred Scott case as instructive. Lincoln thought that every office holder in the constitutional scheme had an independent duty to interpret the constitutionality of his or her actions. And so that holds true with judges. Judges need to be able to look at, the cases before them, and they need to decide whether or not, in this clash between two parties, if the Constitution was violated. And these matters of high prudence in judges thinking that certain questions are beyond their competence. Well, there are certain questions, like, for example, the example we like to give is when judges start pronouncing on the legality of war or how war is conducted. We would rightly make the argument that it's beyond the ability of judges to intrude upon executive determinations. But that itself is a natural law question, because judges aren't necessarily limited in their office by being in session and in not having the information that an executive would have in determining the course of a war.
But also that, as you say, there's the deeper underlying principle is that the safety of the American people cannot be put in the hands of officers who bear no direct responsibility to the lives that are at stake, right, which is also should put a very strong limits and discourage Justice Kennedy from bringing the courts into the battlefield in the Bombardier case, to have the judgments on going on in the battlefield subject to the review of judges. It is beyond this ken. But I think what Garrett was pointing to also is that if those other branches have nothing to do, you're essentially establishing the Supreme Court as a sole, the most sovereign body among us. In which case, as our friend David Forte says, the importance of presidential elections is that we produce the main elector to the Supreme Court, the man who really will appoint the people who will govern us. But as Garrett said, well, look, the Madison said, what's legislation but so many judicial determinations? Even people voting in Congress have to face the question of this thing we're putting. In fact, like you mentioned, the Defense of Marriage Act, where Barney Frank said to me, I think this whole thing is unconstitutional. I say, you make our very point, Congressman. We're saying that Congress should be able to weigh in giving direction on this matter of marriage. If you think this is unconstitutional, you should in fact vote against it, because that's part of your responsibility.
So I want to, talk a little bit about the issues of the day. Of course, we already established what you mean by jurisprudence of natural law. And so I want to start with freedom of speech, because it seems today that on the right, we've kind of adopted the free speech absolutisms, and that mirrors what those on the left adopted in the 1960s. So I was wondering, how would you, grounded in natural law, would speak about free speech, and how maybe you would use natural law teaching in this area?
Yeah, so we just conducted a podcast with the author of a new book meant for a popular audience, the conservative pundit Michael Knowles, in which this really was a significant book, because it was the first time that in recent memory we saw a prominent conservative take a line other than free speech for free speech's sake, and gave it book-length treatment. And really, this is the position that Professor Arkes and really not too many other leading conservative voices have been making. Really, it probably was Justice Alito, or at least the Justice Alito before, the Justice Alito before Matal v. Tam in 2017, that was making the argument that when we say free speech, we still understand speech as bound by the same kind of natural law limits that any rights proclamation has. So in the context of free speech, we would never think that any utterance deserves the protection of the law. The fighting words doctrine case, Chaplinsky from the 1940s offers a handsome example, where you can have a citizen who, by virtue of the very utterance of certain words or phrases, but then also the context in which those words or phrases are spoken, provides the kind of incitement to violence that in itself cannot be countenanced by a regime that treats the protection of speech as anything other than just this kind of flat line, one size fits all regime. So really, what we're trying to do is to have conservatives think a lot more critically about what we mean by free speech, and it's perfectly fine for us to maybe take as a prudential line that in general, speech should be protected. In particular, these flights to characterize certain arguments as hate speech. As a matter of high prudence, we should be willing to countenance more protections of speech. But this idea that it should be instantiated in our law, that we need to essentially adopt the arguments of the ACLU when they were defending the Nazis marching through Skokie, is crazy. And it really, I think, reflects fear more than anything else in a conservative political class, as well as a legal class.
That's very good. Can I just play off that in a moment? John Marshall famously said that anyone who publishes a libel in this country can be sued or indicted, sued for personal damages or indicted as a kind of seditious speech for rivaling up hatred toward a local minority. In other words, he understood, as the founder understood, that not every instance of speech was innocent, that speech could be used as a vehicle to inflict harms, as well as any other aspect of it. There is nothing we can do. There's nothing we can cite. Driving a car, hitting a golf ball, that cannot be part of a means-ends chain leading in a hurtful direction. And so you begin with the recognition, of course you could commit serious wrongs and harms through speech. And when it does, we should be able to look at those misuses of freedom as readily as we use any other misuse of freedom. Now, Garrett mentioned the Chaplinsky, first of all, the sense of, he mentioned that point about, Chaplinsky recognized that the words themselves may inflict injury, the gesture itself. But look, it's not, first of all, there's a recognition that assault does not strictly require the laying out of hands. You could shoot at somebody deliberately, make a dismissive gesture. That could be an assault. And there's also recognition that you don't need a material injury for this. So we had a case in Maryland years ago of burning a cross outside the home of a Black family. It turned out the Black family wasn't there. And by the time they returned, all the debris had been cleared up. And yet the people in the neighborhood had a sense that something seriously wrong had taken place. But it was an assault on these people as a result of their race. See, so in the past, we used to recognize that the fact that it's speech does not mean that wrong cannot be done with it. And as Garrett said, Garrett said, we're leading another direction. We find the ACU saying as Dave Hammond used to say, we must be free to hear the Nazis because we must be free to choose the Nazis. It's so you back into the notion, as you will know, think of that, and with Douglas, that there's nothing so base that it cannot be enacted through a democratic regime. We're ready to, you can enact policy of genocide, slavery. To say that is to say that the laws, the Constitution, the regime is utterly empty of moral substance. But to say that we can reach those things, to say those issues lend themselves to our judgment as well as anything else. But so when our friends at the ACU made that argument, say, so you're free to choose the Nazis. First of all, how do you get this freedom? Free election. on the basis of that proposition. All men are created equal. No one deserves to be, people don't deserve to be ruled without their consent. Well, the Nazis, you're voting solely on the strength of that principle. The Nazis taught us that they will remove that entire regime of rights, including the right of speech or the right of free elections. So this becomes a matter of incoherence. But then you'd say, well, if you're justified in voting in the Nazis will resume all of your freedom, all of those freedoms you profess to regard as. So what you're telling us then is this regime of freedom. You don't regard it as something in principle good and necessary, that we're free to vote it out if something else, some other interest regard comes to us as far more important, some other passion comes to take control of us. But either way, as Garrett said, our friends at the ACLU, in trying to affirm that right, I think an absolute slide, were talking themselves into the notion that there was finally nothing in principle right about this regime of enlarged freedom.
So one of the other topics that I want to shift to is a little bit on abortion, since that's been, for the past couple weeks been a big topic amongst social media and the news and all that. And I know, Professor Arkes, you have spent many years developing your own approach when it comes to abortion. The Supreme Court, of course, is about to hear the Dobbs case on a state law that would limit abortion to the earliest moment when it can detect fetal pain at 15 weeks. So I was wondering, how would you decide Dobbs using the principles of natural law, and then maybe shifting a little bit differently to how do you think what will happen in the Supreme Court when Dobbs is decided? Because I know many people, pro-life people like myself, maybe are unsure about what the court is going to do. And since you probably know some people on the court and how it's structured and all that, I would love to hear your opinion about how that was going to go down.
Well, as to the vote, I think I don't have a Ouija board to tell you how this is going to come out. If they tilt the side of overruling Roe, which they may say, we're going to get hit no matter what we do, so we might as well go just do the most coherent thing we can do. If they go to that side, my hunch is that it will not be 5-4, but 6-3, that John Roberts will not be willing to have such an important decision made by such a narrow vote. But go back a moment. On this matter of fetal pain, people say, well, if that's the problem, don't we just dissolve it by giving an anesthetic to the child in the womb? Would any kind of murder cease to be murder if we anesthetize the victim? And in the matter of heartbeats, the heartbeat doesn't indicate the presence of that small human being. The heartbeat is one other function that comes on, and beneath it all is an underlying nascent life generating and integrating its own growth. If there weren't something growing there and alive, an abortion would be no more indicated than a tonsillectomy. If we understand an abortion, it's because something's alive. If it's alive, we're not in a doubt as to what species it is. It's a small human being. And then, we used to use this abstract that you're familiar with as part of the Claremont crowd, of Lincoln's fragment himself and imagining a conversation with an owner of slaves. Why are you justified making a slave of the black man? It's because he's less intelligent than you. Ah, beware, the night ex-black man comes along, more to slave you. It's because he's darker than you. Ah, beware again, the next white man that comes along with a complexion even lighter than yours may enslave you. Then we say, why is that offspring of the womb less than human? Doesn't speak yet. Well, neither do deaf mutes. Doesn't have arms and legs. Other people lose arms and legs in the course of their lives without losing their human standing. Well, if that's the case, then there's no principal ground. This is the case with Lincoln. There's no ground in which you could rule out black people as rights-bearing beings that would not apply to many whites as well. And here, there's no ground in which you could rule out the unborn child as a human being that would not apply to many people walking about outside the womb. And if that's the case, then the argument has to shift to another axis. The reasons we need to justify the taking of this small life must be as compelling as any just case we'd be obliged to give for the taking of any other life. After all, the laws on homicide are indifferent to the size, weight, age of the victim. The killing of an older man is not a graver murder than the killing of a small child. Well, once those things are in place, it's not a matter of what the Constitution says about persons in any case being extradited, moving across state lines. It's a basic question of, well, we have the government was presented like the Declaration. Why do we have them? To secure our lives, right? To protect us in our natural right. Well, who are the bearers of those rights? Well, not dogs and horses, but human entities, human beings. Well, again, if that's the question before us, not whether abortion's mentioned in the Constitution or persons, but what is this a human being? And if so, what kinds of protections would the law be obliged to cast over human beings?
I just have a more kind of nuts and bolts reply to your question, Seth, about what's going to happen. So Sharif Girgis, our pal, the newly installed addition to the Notre Dame law faculty, had a very trenchant observation this summer when he said that the court, or at least the conservative-leaning justices, all 6 of them, they have a very interesting predicament that by virtue of taking this case, they put themselves in. On the one hand, they certainly have the power to do whatever they want. However, they also have to live with this decision in Dobbs. And so, as Sharif understands it, these 6 will have before them the opportunity to either, as Professor Arkes has said, return this issue to the states, a wholesale repudiation of the Casey framework, or to fashion a new framework, which operates under a different standard than viability and undue burden that Casey and the Whole Woman's versus Hellerstedt line of jurisprudence has given us. And Sharif said it's virtually impossible to imagine a situation where the court doesn't do one of those 2 things. And so, given those alternatives, Sharif says he can't fathom the 6 of those justices having to fashion a new standard. Maybe it's of fewer weeks than Casey, but it's a new standard that they're going to have to justify again and again and again, because the pro-life movement, in particular its legal actors, are going to continue to challenge that. And so if we're to get a ruling in Dobbs that has far more in common with Casey, it will not be the end of the pro-life litigation strategy. And so the only way for these justices to say, we've heard what we want to hear on abortion, and now we're returning it to the states, that's really the only tenable way that the pro-life movement can say, okay, this has now been litigated. Now our avenues turn to the states. Otherwise, you're going to have, first of all, a wholesale repudiation, probably at a crack up of the conservative legal movement. Sure. Not that the justices themselves should be, thinking about that, but inevitably, that certainly is going to enter, any kind of, gaming out of how the Dobbs decision is received. But really, if this matter is returned through the states, you're going to then have, at least in many scholars thinking, including Robbie George, John Finnis, you're going to have perhaps a shift to the argument that the 14th Amendment forbids abortion, but more likely you're going to see legal action, see the action at the state level in trying to enact more provisions like the state of Texas did in SB 8 recently.
Yeah, but see, how many times, it's like how many places after the decimal point? Probably if they simply, I guess that's what they're going to do. If they got to the point, even the pro-lifers would be celebrating a movement to return it to the state. But the point is, unless you say something about why the law is justified in protecting the unborn child, questions of why would the local legislatures be justified in casting protection around that unborn child? Why do we consider worthy protection? On the other hand, if you really do think it's a constitutional right, Why would somebody lose her constitutional right by traveling from one state to another? It's simply buying onto more incoherence. And I'm afraid Garrett's right that the pro-life community would just go along with this. We'll just keep litigating in the courts and we'll argue over 15 weeks, 14 weeks, or something like that. Meanwhile, being entirely off the point. The court, in the first place, should have gotten clear in the first place in Roe as to what the nature of that being whose life is at stake. And that could have just given us the right focus on all of these things. But again, it's like the question of Harry Jaffe's point, whether the black man is or is not a human being cannot be a value judgment. It's something that depends on whether and how many of us value the freedom or lives of black people. We wouldn't think of putting that question out to the states. Tell us, make a value judgment. But the question, why does it make any more sense? Put out to the question, say, do you think that entity recognized by all the books in embryology as human from the first moment? Do you think there's some serious doubt about that? Yeah, we ought to take votes on. And if it is human being, you can tell us what stage you're willing to protect human beings at. Okay. So again, but the difficulty is that courts have been willing to live with incoherence for a long while. They say, okay, yeah, I know, it just doesn't add up, but it'll get us through this day. And it may give the pro-life community more to deal with in the states. But the thing that plagues me here is that the courts have shown a real, almost heroic willingness to live with contradiction.
Well, I have a follow-up question to that, and then I'll get to my last question is, because of we live so long with this incoherence and such, not just on this issue, but a whole bunch of other issues. There's a lot of people who, they look at kind of our side, what I consider our side, the Claremont School, the James Wilson Institute, and the fact that you want to give the judges, maybe instead of them looking at just at the Constitution, but the principles undergirding it and all that. A lot of people, like I was talking to a friend of mine who ran for Attorney General in Oregon, and he was talking about how, well, you want these judges to do all these things, but isn't that just like the problem is, some of these judges are just not clever enough. So why don't we just stick here, stay within the bounds of the Constitution and just read whatever it says instead of going to those principles and trying to be clever in some way. And this is my problem with, the textualist, wing of the conservative movement. But I wonder, what do you say to those people who kind of say, when it comes to something like an issue of abortion and we want to use the 14th Amendment to protect all human, unborn human beings. And they look at us and say, well, aren't you using creative language here and there's the 14th Amendment or whatever to fit whatever ends you want? That's sort of what I've been butting up against lately when I'm talking to these people. Do you have an answer to that at all?
Well, on one hand, the fact that people may make mistakes and do something spurious in the name of natural argument, if that's the case, the proper response is to show where the argument is specious. Not to say what some conservatives say, see how people misuse natural law reasoning? We'll get the better of them. We'll avoid moral reasoning altogether as our solution to the problem. That's no solution. But Garrett, you want to?
Yeah. So our pal Josh Craddock, who was one of our James Wilson Fellows from a few years ago, has definitely been like tip of the spear on this argument that the 14th Amendment secures fetal personhood. And really, I find Josh's argument to be good, but it shouldn't be the only argument we make. The real test is whether there's a colorable legal argument at all to be made there. And I think that's the threshold we should be judging all this against. And the answer is, of course, yes. And so, look, this is much more a study of probably how the pro-life movement fits within all manner of, probably since the 50s and the 60s, public interest litigation strategies. Thurgood Marshall, years and years, laying the groundwork for, Brown versus Board of Education. This should all be viewed in terms of battlefield tactics, not battlefield ethics. If we take one tack here, that's not to foreclose the possibility that another group is going to take another tack on abortion, and all these things need to be coordinated and ironed out. I mean, the real success of the left from the 50s, 60s, and 70s was to create the kind of lawyering community that became overwhelmingly associated with democratic progressive causes. Really, it was only from like the 80s onward, and it's actually Michael Uhlman very early on, part of the conservative counter resistance in the 1970s. Our departed late friend who became part of the conservative state level strategies to create a conservative public interest litigation strategy. This is all part and parcel of having to reconcile what still at the end of the day are those substantive values that we think form part of the the whole connection between law and morality. I mean, if I had one major problem with just in general how conservatives tend to carry themselves, it's a persistent reaction to whatever the excesses of the left, instead of having their own positive program, and a positive program in which they're willing to effectuate through litigation strategies. Jesse Merriam at the now at Patrick Henry College has had a great series of pieces, criticizing the conservative movement, but in particular the conservative legal movement, for not coalescing around substantive values, in a way in which real change can be effectuated.
And I don't see what the problem is. I think this is a problem that should settle itself in about 30 seconds. That if you found the laws of the states withholding the protections of the law from attacks on the lives of Black people, no one would doubt for a moment that the federal government for the 14th Amendment would have the authority and rightful authority to intervene. In fact, go look as early as the 50s, you found the federal government kind of holding back when law enforcement of the South was abusing Black prisoners, or in collusion with local yahoos, acquiescing in the lynching of those people. So you still find, even recently, the community had to learn again, and perhaps learn anew, that yes, the national authority should be able to reach to protect the lives of Black people in the South when those protections were being withdrawn. Well, in this case, you withdraw the protection of the law from a whole class of human beings, and you think there is some kind of legal or philosophic problem there? The question is, are they human beings? Is the law withdrawing the protections from you human beings? Which is, well, so there was an old line of mine from Henry James. I think some of our friends are victims of perplexities from which a single spark of direct perception might have saved them. This should not be as hard a problem as they affect to be.
I want to close out because with this question, because we talked a lot about the conservative movement and how they deal with certain issues, and I want to say historically, for the last in the 70s and 80s, the conservative movement was dedicated to this textualist understanding of just reading what the Constitution says, and kind of gave up on this understanding that you have, Hadley Arkes, of the natural law. And I want to say that recently I've been feeling like there's a resurgence and renewed interest in the natural law, starting with Josh Hammer and the people associated with the common good originalism sort of understanding. And I was wondering if you think that these lawyers and judges will incorporate the principles of the natural law in their own work, and And two, are you just as hopeful as I am that people will start using these natural law principles or not?
Well, if there are a few threads I'm trying to recall, get your first of all, if we understand by the natural law, we don't mean theories hovering in the sky, but those anchoring axioms of the law, which is, as Hamilton used to say, the primary truths or first principles upon which all reasonings must depend. They have this internal evidence, which have deceived all combination of reflection, command the assent of the mind. Those are anchoring propositions, like we know that people should not be held responsible or blameworthy for acts they're powerless to effect. If we understand that, of course they should be taken into account, and if judges make them more explicit, they could give us more of the building blocks. But, Garrett and I were talking about this. I wrote a book called Beyond the Constitution, which I thought is consistently necessary to move beyond the text in explaining the text. Justice Frankfurter said the Fifth Amendment say we should not hold. What's it about witnesses? No one should be compelled to testify against himself. Okay. And the question was, where does the accent lie? Is it against himself? If we give him immunity, can we require them to testify against his friends in the Communist Party? You have to go beyond. What's the meaning of that thing? Well, take something as like the necessary and proper clause. It doesn't explain itself. There's serious argument about it. John Marshall wrote an argument out on it in McCulloch versus Maryland. Jefferson had an alternative, which Hamilton addressed in his memo to Washington National Bank. He said, this deep dish officer, the Secretary of State, offered an argument that embarrasses itself, that contradicts itself. He gave us a compelling argument to explain what necessary and proper clause meant. And he then also showed the Federalist Papers that the logic of that clause would be there. It would be true of any person, any of us would seem to claim only those rightful powers we need in affecting our own legitimate ends. This is what you say of any human being or any moral agent. Well, anyway, apparently we needed that kind of clarity of exposition to explain what those words in the text meant. If that's the case, the challenge here is, how do you do it without that? Now, let's say we'll take an historical understanding. We'll see how it was the framers of the 14th Amendment understood what they were doing. Then the question properly raised them: where is the historical approach? Where is the historical approach contained anywhere in the text of the Constitution? Where did you get that from? So once again, the people are, without realizing it, keep making the moves to these principles outside the text, which strikes them simply necessary in explaining what is reasonable about their judgments. And can I leave it to you as the last word?
So I agree, of course, with everything that Professor Arkes has said. I guess I'll kind of try and distill the moment as you were asking, though, Seth. Like why are we going through this moment? I think part of it, practically comes from how the conservative legal movement has been very patient for a very long time. Yes, there's a purported majority of self-described, conservatives or at least like originalist-friendly justices on the court, but there's also a sense that there's been a long now train of establishing what do we mean by both original public meaning originalism, but then also how do we understand the interpretation of statutes as reaching I think an endpoint. And the endpoint is that we can keep doing this practice as we've done it, and we can view this as kind of the end of history. Or we can say that this has all been, very helpful at rolling back the excesses of the Burger and the Warren courts, and that there really is a moral ground to the law, and it's finally now, being given its moment to shine. Adrian Vermeule, for all of his emphases on the administrative state and bringing about more of a muscular executive. Adrian Dremel, I think, diagnosed the problem quite well in his Atlantic essay last year, but and so has our good friend Josh Hammer in his law review articles on common good originalism and his writings that we've shared with him. But I mean, this really is the Arkes Jaffa position that really it's been here the whole time. But now I think because of this fear of the Burger and the Warren courts receding, now it really does have a burgeoning young core of interested practitioners that want to give it a chance. And so if personnel is policy, we see a rising cadre of young lawyers that are willing to make both the Scalia type textualist originalist argument, but also the argument that we would have that originalism, rightly understood, incorporates a wide berth of natural law reasoning as the founders understood legal interpretation.
And you guys both of you guys have been leading that fight at the James Wilson Institute. Your guys' fellowship definitely is helping bring those kind of clerks and those judges, maybe soon to be judges, in our law fields and such. So I think that is awesome that this is what you guys are doing. I'm hoping someday you do one with with just young professionals or something along those lines, because it's not just for the judges.
Oh, sure. We've had businessmen involved, and that's right. Or citizens want to know these things. Citizens want to know these things.
Yeah, exactly. And which is why we partly did this podcast, because these principles are timeless, and citizens can know these things. So I know you guys are on a hard off, so thank you so much for your time, Professor Hartsock.
Always a pleasure, Seth.
Thanks so much for arranging it, Seth. It was very sweet of you.
Thank you.
I hope we'll see you again.
We will. Thanks again.
Bye-bye.
Bye.